Thank you. Good morning, and may it please the court.
Wait till people have left the courtroom.
Oh, I'm sorry.
No, that's okay.
Thank you. May it please the court, Mr. Chief Justice. Mark Bender appearing on behalf of the plaintiff appellant, Nickola. If I may, I'd like to reserve 3 minutes for rebuttal.
How many minutes?
3.
Okay.
As the court is aware, this case arises under the Uniform Trade Practices Act, a fairly comprehensive set of statutes regarding insurance practice in the state. The specific provision that we are dealing with is 500.206 sub 4, which deals with what's commonly called penalty interest. The interest of 12% that's assessed against an insurer under certain circumstances when payment is not made in a timely fashion. As this court recognized in Yaldo and the Court of Appeals recognized in Griswold Properties, the statute creates 2 separate criteria for when the 12% interest is payable. The first sentence applies, quote, if the claimant is the insured, close quote, and, quote, if benefits are not paid in a timely basis, close quote. If you fit those criteria, you get the 12% interest, but it's not paid in a timely fashion. That's the only limit. With respect to a third-party claimant, if it's reasonably in dispute, then there is no 12%. And I think quite clearly the statutory language is fairly clear and has been recognized as such in the Yaldo and Griswold Properties cases. The Court of Appeals in this case seemingly gave some lip service to it and said in substance, if you follow this language, the plaintiff wins. Why? This is the insured itself, and it's a contract claim. He's not a third-party claimant subject to the reasonably in dispute criterion. But it carved out, really, a judge-made exclusion for underinsured motorist coverage.
Is the term a third-party tort claimant defined anywhere in the statute?
That specific language isn't, but we certainly know what a tort claimant is, don't we? Someone who files a lawsuit in tort.
Sure.
And this is a contract case.
No, I'm nowhere in the statute, though, it doesn't say anything. I think that I'm not asking a question that's adverse to you or favorable. I'm just asking a question.
No, I'm sorry if I took it that way.
It's really a term of art that's been used by lawyers since the beginning of no-fault law, wouldn't you say?
It's certainly used without any thought that I'm aware of that it's really controversial.
When I heard the term, I'm assuming it's not a claim between the insured and the insurer. It's an outside claim, usually relating to whether there's a serious impairment, right?
Well, that's certainly one of the elements of the contract claim.
No, of the tort claim.
Isn't the insured basically stepping into the shoes of a third-party tort claimant in order to demonstrate that he's entitled to a greater recovery than he received from the third party's insurance company due to the policy limit?
I disagree that they're stepping into the insured. What they are doing is providing a product, insurance, that says if you don't receive a certain benefit elsewhere, we will pay it. And it's right that it depends upon whether or not an available recovery exists as to a tortfeasor. But they're not really stepping into the shoes. They're not defending him in that action or anything else. They are simply promising, as a matter of contract, to pay a certain amount of money if certain conditions are met. And let me, if I can, suggest an analogy that may help understand why the Court of Appeals is wrong. Let's take common indemnity insurance, where the insurance company says, if you are held liable for negligence, we will indemnify you from loss. The core insurance. But that still depends on a tort. It depends upon a finding of tortious conduct and a tortious judgment against the insured. So the fact that there may be an element of the contract that overlaps in some fashion with tort doesn't change the nature of the cause of
That's
action.
how you prove the breach.
Pardon me?
That's how you prove the obligation or breach.
It's one of the elements of proving the breach of the contract.
It's one of the elements. It's not the only element,
Right.
though. And let's take it a step further. If we were to recognize that this was a tort claim, wouldn't we be entitled to mental anguish damages and all of the other non-economic damages that are traditionally available in a tort action? But we're not. We are entitled only to the number of dollars that has been determined. That's why it's a contract action. And the fact that it may have this overtone really doesn't change the statutory language. The statutory language looks to the nature of the claimant, his or her identity, whether they are the insured or whether they are someone other than the insured. And some of the case law explains why. I mean, you certainly have greater duties to your own insured with whom you have a contractual relationship, and that's why it is a lesser standard for 12% interest than it would be with a third-party tort claimant. And in our view, it reduces to a fairly elementary issue of contract construction. Are my clients third-party tort claimants? They're not. They're the insured, and their claim is in contract. They don't fall within the second
Mr.
statute.
Bender, you've got a very persuasive argument on the basis of the statutory language. I'm going to ask you to just change roles. If you represent the insurance company and you've got some concern about whether the entire $100,000 of underinsured benefits would be properly paid here, but you don't want to pay the penalty interest of the 12%, what do you do? How do you advise that client?
First of all, it's sort of you pay your money and you take your chances. If you are correct that this is not covered, there's no problem. The problem comes when you do not pay benefits that are truly due. This is no different, I think, other than in degree perhaps, to any other insurance. When a claim comes in, take the Griswold instance, for example, or Yaldo, you've got a fire insurance claim, and you have some doubts whether or not there is coverage. Is it arson or is it an accidental fire? You've got those concerns. And when the claimant, your own insured, comes in and says, it burnt down my house and it's going to cost $40,000 to fix, and you say, maybe it's only going to cost $30,000. Or maybe your couch was older than you say it is and depreciates a little bit more. The fact that there is some uncertainty is part and parcel of the insurance process itself. And so the so-called uncertainty that you're dealing with is nothing other than perhaps in degree different in a UIM case than it is in any other case. And moreover, it seems to me the statute reflects a significant legislative policy, because if you transform the reasonably into dispute back onto the insured, there is no incentive on earth for the insurance company to promptly pay claims. That is the incentivizing process that's part of the code itself.
Well, there's more incentive. The way the statute is written,
Well,
there's greater incentive to settle a claim with an insured than perhaps one that is in the third party. That 12% is a fairly significant inducement, but there's a recognition in the statute, it appears, that the insured is entitled to less controversy with its insurer than somebody who is a tort claimant.
True. There's one other thing I came across when I was preparing for this argument, and I neglected to notice it, mention it in the brief. I've gone through some of the other provisions of the Uniform Trade Practices Act. Not in any great detail, but what I learned is there are several provisions that are unique to one form of coverage or another, or exclude. For example, 2008 deals with workers' compensation insurance. 2011 deals with disability insurance. 2019 deals with life insurance. And the point there is that when the legislature wishes to exclude or include a specific type of coverage, They know how to say so. And in this particular statute, there's no indication whatsoever that one can make up exclusions of underinsured motorist or uninsured motorist or any other form of coverage you might care to drag out. It simply has no basis in the statutory language. And for the reasons I've mentioned, I think there are some very good reasons that the legislature did what it did. It may well have thought it a better policy to cut insurers more slack and say reasonably dispute applies to everybody. It could have said that. And it would have been a rational thing to do, but it didn't.
Why don't you say 4.5 minutes instead of 3?
Okay, that's exactly what I'll do. Thank you.
Well, let me ask you one question, so
Sure.
we'll get you back to 3 if you don't mind. Can you tell me why you believe you're entitled to penalty interest for the 6-year period during which there was not a third arbitrator selected, apparently as a result of lack of diligence on your part?
Well, first and foremost, because the statute says if you don't pay it in a timely fashion, here's where it goes. It's from 60 days after the claim to payment. Now, in this particular case, the claim had already been improperly rejected under subsection 1, I believe, or 3, subsection 3, which basically says as your own insured, you submit the claim. If the insurer has any problems with your claim, it has a certain period of time to say, we need more information. Provide it. And if the insured doesn't do that, and I think it's the Argot case we cited in our brief, if the insurer fails to ask for additional information, at that point, it becomes overdue. And in this particular case, if you look at some of the documentation for our original application, we provided all kinds of medical information, offered to provide anything more they might want, and they just ignored it. They didn't say.
But the question, I think, is both parties contributed to the delay in resolving it
Sure.
for 6 years. So who should bear the risk of loss for that inaction?
I think that the party that has failed to pay it in a timely fashion and that would otherwise benefit from the delay. And in this particular case, there's nothing in the statute which exempts that period of time. Now, I agree both were at fault, either could have moved forward, but consider the alternative.
You got two and a half minutes now.
Okay. When you've got a three-arbitrator situation, yours, mine, and ours, then that would enable the insurance company just to pick an intransigent arbitrator who wouldn't help pick a third. And that's sort of our view of what really happened, but it's a side note.
Why don't you save your time then?
Thank you.
Thank you.
Thank you, Your Honors. Nathan Poplinski, appearing on behalf of MIC General Insurance Company. I think this court has asked some simple questions in this MOA.
Simple in the sense of not being complex, you mean?
I don't think that's a complex issue.
Simple-minded.
As opposed, yes, Your Honor. I think that the central question is this person in the shoes of a third-party tort claimant? And they are, because they have to prove a third-party tort case. Every single time in these uninsured and uninsured motorist claims, they are only entitled to benefits when they are legally, the language that is always used is that they are legally entitled to benefits. So they have to prove a third-party tort case in every single time. So that entails, in these cases, they have to prove tort liability of the driver, they have to prove their own freedom from comparative negligence, they have to prove a no-fault threshold injury, they have to prove exhaustion of their non-economic damages, of the underlying policy of the underinsured driver. They have to also show that by contract they meet the definition of an underinsured driver. All of these things have to be met in every single case. They have to prove that tort case. And I think that this statute is divided into, as I think your justices have recognized, the third-party cases versus first-party cases. The first sentence of this statute references insureds, individuals, and entities who are, the language is, directly entitled to benefits. The uninsured motorist claimant is not directly entitled to benefits until they prove the third-party tort case.
Counsel, I'm having a great deal of difficulty understanding and accepting your argument that because the contract claim requires a particular set of proofs, that those proofs transform a contract claim into a tort claim. That's what you're arguing, aren't you?
I think that we could go back to the case of Rory versus Continental Insurance.
I'm asking a very simple question. Isn't that what you are arguing? That if I, in order to satisfy my obligations under the contract, to get the uninsured, the differential between what I was paid and what my contract with my insured provides, I have to prove all these elements that are part of a tort claim. That makes my contract claim a tort claim. That's what you're arguing, isn't it?
Essentially, Your Honor, I believe that's true.
All right. So now I don't get the contract recovery. I get the tort recovery if I'm successful on those proofs.
You
right?
get to, no, Your Honor.
Well, wait a minute.
You have contracted
wait.
for a tort recovery that's limited by the amount that you contracted for.
If I'm not making a tort claim and entitled to tort recovery, then I don't understand your argument.
I think we go back to Rory versus Continental Insurance, which you yourself wrote.
I'm kind of familiar with it.
What that case said is that the uninsured and in turn underinsured motorist benefits are not required by statute. They're a matter of contract. So technically this is a contract claim in which you are agreeing, which you agreed that you are going to prove a tort case.
Yeah, proofs are not the same thing as the cause of action. That's why your argument is causing my head to spin.
The only reason that you have to prove a tort claim is because your contract says so, correct?
That is correct.
So your contract says that's one of the things that has to be proven.
That is correct.
That makes still a contract claim.
It's a contract claim, but it's not a contract claim in which you are directly entitled to benefits, which was the key language of that first sentence.
Why aren't you directly entitled to benefits if you've proven all the things necessary to be entitled to benefits? I mean, they are the insured, and all you're saying is in order to recover under this contract, you need to prove these other things. If you've done so, I mean, the fact that the proofs are complicated, you think makes it indirect?
I think that the proof of the tort case makes it indirect because of the, essentially I believe that this is the difference between the first party claims and the third party claims that I think this statute is intended to split between. First party claims are simple statements of you are automatically entitled to benefits. A fire occurs.
But automatic, so you want to say automatic means direct. Direct means automatic.
Direct means automatic. I would say that.
I don't even see direct.
Directly entitled to benefits.
Directly entitled.
Directly
or
entitled.
entity directly entitled.
There are you are aware, alternative interpretations of what direct means, are you not?
I mean,
Directly entitled.
Directly entitled. I mean, directly is defined as
with
at
nothing
once
or no one in between, in proceeding in a straight line or by the shortest route. Those are alternative interpretations of what direct means. You've chosen not to rely on those, and I'm wondering why your somewhat convoluted interpretation of direct is the one that this court ought to adopt in this context.
I don't believe that this is a convoluted definition of direct. It's the definition that's used in the dictionary.
Along with multiple other definitions, right?
Well,
Direct
yeah,
is
I guess
automatic? You think direct is automatic?
at once or without delay, immediate.
But even then,
I guess in a straight line, just wouldn't fit into the sentence. entitled in a straight line to benefits. I think.
But no one is immediately entitled to benefits, right? You have to submit a satisfactory proof of loss. If it's not satisfactory, then the insurer can send it back and say, send us this other stuff. Right? There are hurdles for everybody to jump through, even someone who I think you would concede is directly entitled to benefits. There
are some steps, but the language of a first-party contract generally says once the event occurs, you are entitled to payment.
But counsel. No, you go, Chief. No, I guess my question is that, am I to understand on your theory, it would be that every contract, every insurance, that basically every relationship you have with an insurance company is through a tort action, not through a contract action, which I think is what Justice Larson was getting at. In what scenario would you have, based under your argument, what scenario could I have where I enter into a contract with an insurance company where I'm not having to litigate under a tort situation? And where would that, under your analogy, every single time I buy insurance, it's not a contract, it's a tort action?
I disagree with that assessment, Your Honor. I believe in the differences between first-party cases and third-party cases. In first-party cases, it wouldn't be subject to litigation because once the event occurs, whether there's a fire or there's a PIP claim.
But you don't just write me a check. If I come to you and I say, let's say I have a first-party action, right? And my car is totaled, or if I was driving, my car would definitely be totaled. So let's say I come to you because my car is totaled. You don't just write a check, do you? Isn't there still a set of proofs that I have to go through before? I mean, would your company, because maybe I should sign up for your company, so, and then get a license. So if I'm driving my car and inevitably I crash it within 30 seconds, do you just come and give me a check then for $50,000 based on what I tell you is my loss?
No, Your Honor, you still have to satisfy a satisfactory proof of loss, which is just the event.
Isn't that the same thing you have to do in an underinsured claim too? You have to provide satisfactory proof of your loss, which is the differential between what you were paid and what your contract with your insurer would pay. Isn't that that's the proof, right? Proof of loss.
The proof of loss in this case doesn't work in the third party.
The elements of that proof may be different depending on the nature of the loss, but it's the same obligation, contractual undertaking, correct?
I disagree, Your Honor.
Okay.
The reason for that is if you look at these cases, what could be the proof of loss in this case? The proof of loss would have to be the tort action. In this contract, what they agreed to between these two parties is that the proof of loss essentially is the arbitration. Once the arbitration occurs, that would be the proof of loss. But technically in this case... But
the arbitration would arbitrate the elements of an underinsured claim. You still have to prove the elements of the tort to get the recovery in arbitration or in court, right?
Either in arbitration or in court. That's
somebody has to make a determination, whether it's the insurance company or some fact finder has to make a determination that the elements of the contract have been satisfied, such that the insured is entitled to the differential between what he was paid and what the insured's own contract would pay.
There has to be a determination that there is any difference at all to begin with.
Yeah.
There has to be that tort case has to occur in every situation. And that's why, again, this is a third-party tort action.
Let me ask you a more text-based question. I kind of get the feeling that the legislature didn't say first party, third party, but it did say third party. It said insured and then third party tort claim. Is it your theory that the legislature either didn't cover underinsured claims in this calculus, this, or what? I mean, because it seems to me what we typically call first-party claims, those directly between the insured and the insurer, and third-party are covered here. But you seem to be arguing that there's a third species that isn't covered.
I think there's two ways to look at it, Your Honor. I think the way the Court of Appeals looked at it, I think is correct in that the first sentence deals with first-party claims based on the language directly entitled to benefits. But if Your Honors are not comfortable in saying that that applies, I think that the second possible argument is that uninsured motorists are just not covered by this statute, which I think is a perfectly reasonable alternative reading of this. What I don't think is a fair reading.
Not a species of first-party claims.
I don't think that it's a first-party claim, Your Honor. I think it's a third-party claim, because you have to look at what is the actual.
And yet you can't get third-party damage recovery.
Well, you are getting third-party damage recovering, but you've already agreed on what the limits of that recovery would be.
Why? Where have I done that?
By choosing the limits of your insurance. Between you and the insurance company, you said, I'm worried.
Contractually, right?
You've done this contractually, but what you've said, I'm worried that everybody else on the road isn't going to carry enough insurance. I want to insure them. I want to insure them for this amount.
I expect my insurance company to pay it to me if I'm entitled to it.
And you are entitled, and what you agree to, the process that you agree to, is to go through arbitration, and then even after that, according to this agreement, even if the arbitrator sets an amount, you still have the right to claim, I want to go to trial after that. That's what you've agreed to.
Let me ask the question that Chief Justice Martin asked your opposing counsel. These parties let the arbitration process languish for 6 years for want of appointment of a third arbitrator as provided in the agreement. Who should bear the risk of that delay?
I think in this case, Your Honor, if there's any bad faith or any delay, this was caused by the Nickolas in this case, because they are the party that were claiming additional rights, that were claiming additional dollar amounts. By inaction, they implied to the insurance company, we agree with your assessment that we're not entitled to anything else.
The started out by denying that there was any arbitration available under the contract.
And they made a mistake, Your Honor, but once the case was filed, and which applies.
Well, if I were an insurance company and knew I was potentially liable for 12% for delay, wouldn't you as good counsel advise the insurance company, get that arbitration going?
I think what would happen, Your Honor, is we would have to advise our company just to pay. But the question is.
No, the arbitration's been invoked. You're the attorney for the insurance company. And being a good lawyer, you've got all these things docketed, and you look up and it's now, 6 months. Don't you advise the insurer to get this moving?
I think, Your Honor, what would happen with that 12% if you applied it beforehand, you couldn't take the case to arbitration, because in every arbitration case, one side would be facing a 12% penalty for that arbitration case, even though both sides previously agreed to it. So I don't think that's what's intended by the legislature. I think the legislature in this language is clear, and I think consistent with the legislature, Yaldo said that the automatic penalty interest only applies where the actions are based solely on contract. This case is not based solely on contract, so I do not believe that this court should overturn Yaldo.
But counsel, I know we're at the risk of being circular. I want to just revisit this issue of contract, and I apologize if it's circular, but help me to get this, because what I'm trying to grasp is the idea that at the end of the day, when I do an uninsured motorist coverage, I'm still, maybe I just haven't gotten, I'm just not understanding your answer. I buy UIM, I'm entering into a contract with you or your client for all intents and purposes to cover me if I get struck by a driver who is underinsured. What I guess where I'm lost is that it seems to me like that's a relatively straightforward contract. The only distinction is that there might be a set of proofs that come from the amount that is owed. But what am I missing?
I think, Your Honor, what you're actually contracting for is you're contracting for the insurance company to insure everybody else on the road besides you. So what you're actually contracting for is to be a tort claimant. In your contract between the two of you, you've said, this is what I agree to prove, and that what you agree to prove
So that
is the tort
transforms
case.
it from a contract to a tort.
I think that by agreement, and under Rory, they have the right to make that agreement. They move this case into a third-party tort claim.
Counsel, if this court disagrees with you on the directly issue, on the solely on the basis of contract issue, and exposure to penalty interest, is there any basis for distinguishing between the 6-year period raised by Justice Young and any other period in this case?
I think there is, Your Honor. If there was a delay caused by the insurance company, it was the mistake that they made regarding the agreement to arbitration.
Is this a textual basis for distinction or something else you're arguing here?
There's a factual basis in this case. I think there's the difference. The intent behind this statute is to punish a dilatory insurance company, and this insurance company was not dilatory for most of those 6 years because they were made to believe by the claimants that they were not pursuing the claim any further.
Okay, thank you very much.
Thank you, Your Honors.
Two quick points with regard to the 6-year carve-out that has been suggested, if you will. And as Justice Young pointed out, this began when we asked for arbitration, and despite the fact that their insurance policy said so, they said, we're not going to give it to you. And that took the first year, so if you're really looking at fault, that's where you might start. But beyond that, the statute is self-clear. It says they're to pay interest, quote, from a date 60 days after satisfactory proof of loss, close quote. That's what triggers it. It doesn't say after the plaintiff acts appropriately or after arbitration.
How do you determine whether it was paid on a timely basis?
Pardon me?
How do you determine? The first part of that sentence that you read starts, if benefits are not paid on a timely basis. How do you determine whether they've been paid on a timely basis?
You look at subsection 3 in conjunction with the ultimate award. Section 3 says, I believe it's 3, in substance, if the claimant, in the Argot case, if the claimant submits proof of loss and you don't request additional information, then that is considered satisfactory proof of loss. And that's what we have here. We submitted all the appropriate documentation, which ultimately supported the award we got. So in the first party, the insured claim, you simply look at whether they paid, whether the claim was due, and whether they paid it after they got satisfactory proof.
Well, were any of these arguments counsel raised in the Court of Appeals, the timely basis argument, the adequate proof of loss, what to make of the 6-year period? Do we need to remand to this to the Court of Appeals, even if we find that your textual arguments are superior to those of opposing counsel?
I don't think so. And if you buy my textual argument, the statute itself says 60 days after proof of loss. And for the same reasons, you can't create a judicial underinsured motorist carve-out. You can't create a 6-year carve-out because it's the same principle. And one final thing, if you'll allow.
But did you ever submit a satisfactory proof of loss? I mean, the insurance company wrote you back and said, no, this doesn't do it for us. And then they said, please send us medical bills or whatever. So why do you think your proof of loss was satisfactory?
Because under the Argot case and the statute, subsection 3, it's got to be submitted in 30 days, ask for additional 60 or whatever. And so we submitted everything they asked for. They never said that there's anything unsatisfactory about your proof of loss. If I could have one.
Go ahead.
I'm sorry.
No, go ahead.
I think we can put to rest their claim on the directly by looking again at the statutory language. It's 12% per annum, quote, if the claimant is the insured or a person directly entitled. When you've got the person being the insured, you don't even have to look to the second alternative.
Thank you, Mr. Bendier. Thank you.